for coming in late. I had another hearing in appropriations with Secretary Kennedy, and I'm sorry I missed the opening. Special thanks to Ms. Daskell and Professor Donohue, our witnesses that I was not here to introduce. Thanks, Senator Grassley, for doing that. So I'm sure most of us were watching the Cubs-Sox series in Wrigley Field this weekend, and I was struck by the fact that they were doting on the capacity they had with a drone to show images of Wrigley Field from angles and perspectives never known before. It was beautiful, and the Cubs won, so it was a good day all around. But it raised a question in my mind that I wanted to pose to several members of the panel here. If I were sitting in Wrigley Field with a friend or son or granddaughter, and I saw a drone overhead, I would want to be sure that it was a safe and friendly drone. I don't know that when I'm sitting there. Somebody has to find out, or at least ask the question. With over 1 million drones in our country today, and drones possibly hovering over fields of sports and other things, it raises the question of who's going to monitor that activity to make sure these are safe vehicles, air vehicles, that don't endanger anyone. At the same time, those drones could be gathering information, not so much at a ball field, but maybe even a wedding or someone's home. There's a privacy angle there too. Who's protecting the privacy of the people that they are broadcasting or gathering information on? So I'd like to ask Professor Donohue, how do you balance this? The drones over Wrigley Field, are they friendly or not? The gathering of information in my own backyard, is it anybody's business? Who's protecting me?
Thank you very much for the question. As a matter of large-scale outdoor events, for instance, most states have regulations and laws in place that prohibit the flight of drones over certain large-scale events. They require that there be agreement, some consent from the property owner or from the venue owner in order, or some sort of contract in place. In terms of how to balance those rights and the privacy, most states, they actually have carve-outs saying that others cannot fly drones over private property without the consent of the property owner themselves, because owing to this ancient doctrine of ad coelum, property owners own the adjacent airspace over their land, and so they have the right to exclude drones.
But let's talk about the practical world. Sure. You've got air traffic controllers monitoring commercial aircraft, other aircraft, but in terms of monitoring actual drone activity to the point of knowing whether it's complying with the state law, and if it's not, what to do about it, what's the answer there?
Anything below 400 feet is within the state domain. That is adjacent airspace.
How is it enforced?
Through state monitoring of this. There are agreements with the FAA, for instance, if you need to have a temporary flight restriction over particular areas, as during, for instance, the Super Bowl. In those cases, the way to balance the civil liberties concerns is to make sure that there are restrictions. For instance, you don't extend the Super Bowl coverage for a month, and you don't extend it over any land or any drone anywhere in the country, but it has to be a drone that's actually adjacent to that particular site. So when the federal government is involved, if there's the potential for the federal government to take down a drone or to interfere in its operation or to conduct a search of the device itself, then there needs to be some nexus to the actual open air facility or the place that's trying to be protected.
Professor Donohue, if counter-drone authorities are not drafted carefully, could they permit government authorities to intercept data or communications in violation of the Fourth Amendment?
Yes.
Thank you for that. Mr. Chairman?
Senator Lee. Thank you, Mr. Chairman. Thanks to each of you for being here. Over the last 15 years or so,